I'd like to welcome you all tonight, this afternoon, to the Kastenmeier Colloquium. I'm Peter Karstensen. I'm the Associate Dean for Research and Faculty Development here at the law school, standing in for Dean Davis, who was on the phone to me a little while ago saying he would much prefer to be here, but he's been sent to Philadelphia. And so he sends his greetings from a somewhat remote location. It's my pleasure then to welcome you to the law school and to the Kastenmeier Colloquium, and to introduce the gentleman for whom this colloquium is named, Bob Kastenmeier, a 1952 graduate, if my records are correct, of this law school. The man who, on whom I cut my political teeth, is that quite the right way to put it? But as a high school student, I worked in Bob's successful 1958 campaign, passing out bumper strips for him in various shopping malls around Wisconsin, and so it's a particular pleasure for me to welcome a distinguished graduate of this law school, a gentleman who's served for a number of years with great distinction in Congress. And Bob gets the pleasure of introducing the panel and introducing his successor in Congress. Bob.
Thank you very much, Peter, and I'd like to take this opportunity to thank you and the law school, Dean Davis, and all the others, Teresa, who helps put this together every year, and indeed, to the extent it's a success, make it one. Obviously, you know the subject this year is sentencing criminals after a quarter of a century. Where are we? It is a subject which is a perennial one, but I think particularly relevant this year. Before we get into discussing it any further, however, it's my honor to introduce a very special guest. As Fred pointed out, or Peter pointed out, Fred is his brother, also worked in the campaign. I'd like to introduce the Congresswoman from the 2nd District. I know that you presumably all know Tammy Baldwin. Tammy, I don't know whether you really knew that she is really a local product. She graduated from West High School first in her class of 510 people. That's some achievement. She went to Smith, graduated from Smith, came back here and got interested in politics. Served briefly on the City Council in 1986, served 4 terms on the county board, and then moved over to the State Assembly and served 3 terms there with very great distinction. She represented, I suppose, Madison as well as anybody could. The heart and core, the central part of Madison, including this part of the city as well. She and I was very pleased that she decided in 1999 to try for the Congress, because I have always thought the Congress was a great place to serve. She won. She won in 1999, and she was reelected in 2000, and she serves, interestingly, on the Budget Committee and on Judiciary Committee. I mention that particularly because virtually all the subjects that this lecture series has been concerned with emanate from the House of Representatives Judiciary Committee. These are issues, whether intellectual property, the federal courts, privacy, sentencing. These are issues that emanate out of that committee, that come out of that committee, and we deal with. And so I think it's just very appropriate that Tammy, who is a member of that committee, be recognized, and I'm pleased to present her for a few remarks. Tammy.
I very much appreciate the opportunity to welcome you here, Congressman Kastenmeier. This is an extraordinary event to have this annual colloquium, this opportunity for some of the best academic minds, the best practitioners, to talk about best practices on this topic and the many others that the colloquia have covered over the years and will cover in years to come. I just want to take a moment to tell you what a remarkable privilege it is to be able to fill a very small part of the shoes that Bob Kastenmeier filled in the House of Representatives. Earlier today, I was in my office here in the district, which happens to be in the same building that Congressman Kastenmeier's office used to be. And I believe I sit behind the same desk that Congressman Kastenmeier used to sit behind as he did his work in the district. It is so fitting that this colloquium is named after him and all of his efforts. I had a chance a couple years ago to hear some of the inside tales of what happened on the Judiciary Committee during the days in which he served. And one of the most remarkable things was how he brought that committee out into the field and made sure that they visited federal prisons and institutions and understood, not from a distance, but from talking to wardens and guards and inmates, what it meant to do the job that they were doing in the House of Representatives. And you don't find many role models like that anymore in the Congress of the United States. We were so privileged to have him serving us. I was, as a person growing up in this area, and that legacy is continued through this particular series. So I thank you for the brief opportunity to be here, and I appreciate, on behalf of all of us, the opportunity for us to learn and discuss and move towards better public policy. Thank you.
Thank you very much for those kind words, Tammy, and good luck in your service to this district. As I said, I think that the subject today is one that is of continuing interest, partly because a lot has happened in sentencing over the years. I can remember when the judiciary used to have a little more discretion in terms of handing out sentences. As a matter of fact, I remember Bill Kaplan reminds me of this, that many years ago, Judge Jim Doyle, someone whose memory I certainly honor, one of the great jurists, I think, in the system, federal system, once was confronted with a case involved because the Congress had passed a bill in the 60s with all the wild demonstrations and everything else, had passed a bill which made it a crime to assault a federal officer, meaning a congressman or a senator. There thereafter occurred very shortly a person fairly well known in this district who was a radical who spat on poor Henry Jackson, a senator from the state of Washington, who was visiting in town. And of course, people were very anxious for the federal court to take this matter up and to hand out some really severe punishment. And they were surprised and crestfallen when Jim Doyle didn't hand out that sort of punishment. As a matter of fact, when asked for an explanation, Jim Doyle said, well, it was a small offense committed by a small person and deserves a small punishment. It's that sort of sentencing wisdom, of course, which has gone by the board. Now we have a system incorporated by the Congress in 1984, put into effect during 1986 and 87, which sets forth guidelines. And on top of that, the Congress has been active in other respects affecting the guidelines or even minimum sentencing. Also, I should say that during this period, the Supreme Court has been very active, and even in a series of decisions last year in Principi versus New Jersey, handed down a major decision affecting sentencing. And so the continuum goes on, and where we're actually left and how effective the system has been is, I suppose, an open question. But here to deal with it today, and I'd like to introduce our panelists, are John Steer on your right. John Steer is from South Carolina. He got his undergraduate and master's degree from Clemson and graduated from the University of South Carolina Law School. He went up to Washington and served on the senior senator's staff, Senator Strom Thurmond, as his legislative director, later moved over and served on the Senate Judiciary Committee. Years later, after sort of an interim, he joined the newly created Sentencing Commission as its first general counsel. He remained as general counsel for 12 years until 1999, when in November, President Clinton appointed him a member of the commission, and he is the vice chair today of that commission. There's no record of whether in January 2001 President Clinton granted him a pardon or not, but I assume that that did not take place. Anyway, we're very pleased to have John Steer with us. Next, I'd like to introduce Douglas Berman, who is seated next to John Steer. Professor Berman is assistant professor of law at the University of Ohio State University. Has long been interested. He's one who teaches criminal law and criminal sentencing and punishment. He, most notably perhaps, is an editor of the Sentencing Reporter, the National Sentencing Reporter, which is so important. And he's written many subjects on many times on this particular subject. And so we're delighted to have Professor Douglas Berman with us. Next, I would like to introduce someone from your own law school. He is Michael Smith, and he has a long, distinguished record. So long and distinguished, I'm not going to recite it all. He did work New York State with the Vega Justice Institute for 15 years. He served on their sentencing guidelines, New York State Sentencing Guidelines Committee as an advisor, and has served in any number of capacities over the years. And of course, the law school here was delighted for him to come here. He is now one of the people who helped run the Frank Remington Institute, which deals with a series of issues, including sentencing. And so we're delighted to have Professor Michael Smith here. Last, I'd like to introduce the moderator. The moderator, who has a long Washington history, came down, served in the Justice Department's criminal or civil rights division for several years, and then joined the House Judiciary Committee, where he served over 15 years on the Criminal Justice Subcommittee of the Judiciary Committee, and was a participant at the time as a legislative counsel at the time of the enactment of the Sentencing Commission. He presently works for the Administrative Office of the United States Courts, so he's actually worked in all three branches of the federal government. He also, I should say, is a graduate of the University of Wisconsin and a graduate of the University of Wisconsin Law School. So we're delighted to welcome him back home, so to speak. And I should also say that I count Tom Hutchinson as a personal friend of mine. Tom, I'll turn it over to you.
Thank you very much. Appreciate the introduction. The procedure there this afternoon is there will be time for questions. We'll stop a little before 5 for some questions. But before then, we're going to address some general background matters to give some context for some questions, which will first look at what Congress intended when Congress changed the system, and then some questions about how the Sentencing Commission went about its formulation of the guidelines and some of the decisions it made within the guidelines. By way of background, let me give a brief sketch of what the federal sentencing procedures were at the time Congress enacted the Sentencing Reform Act of 1984. Federal judges had wide discretion in selecting the sentence. The only constraint upon their discretion was that they could not exceed the statutory maximum. There was no statutory statement of why we imposed sentence, what the goals of sentencing were. Judges were free to pick and choose anything from probation up through the statutory maximum. If the judge did impose prison time, the offender was entitled to good time credits of up to 1/3 of the sentence. More importantly, was eligible for parole. Defendant was eligible for parole after service of 1/3 of the term that was imposed, or even earlier if the judge decided that an earlier eligibility was a good idea. Significantly, the judge's decision was final. There, in the federal system, was no appeal of the judge's sentence. It was a decision that the trial judge made, and it was the final decision. That, in general, was how federal sentencing worked up until the Sentencing Reform Act of 1984. Professor Berman will talk about now what led up to the enactment of the Sentencing Reform Act in general, some general observations for background, and then Commissioner Steer is going to talk about how the Commission responded to that. Then we're going to look at each of those aspects in greater detail. Professor Berman?
Thank you, Tom. As Tom suggested, really discretion, complete discretion, was the hallmark of the old model of sentencing before the Sentencing Reform Act was passed. Both sentencing judges and parole boards had basically unfettered discretion to make their choices within some broad limits, but at the core, even though it was never explicitly stated in any federal law, was an idea that had gained prominence throughout the sort of early 20th century, which was the rehabilitative theory of punishment, what some called a medical model. The idea being that punishment should fit the offender. In fact, as some people would describe it, that treatment should fit the offender rather than have a specific punishment to fit the crime. And in many ways, that underlying idea is what was the basis for providing judges and parole boards with such extreme and uncontrolled discretion. The idea being you needed to individualize each sentence. A judge needed the full range of power and authority to judge what particular treatment in terms of punishment this offender needed in light of who that offender was, background, circumstances, some aspects of the crime, but the thought was you put any restraints on that based on what the crime was and you were going to undermine some of the premises. That model held sway throughout this discretionary period, but particularly in sort of the late 60s and early 70s, a number of academics and researchers started to identify some big problems with that whole theoretical model and how it was playing out in practice. And interestingly, this was a story that sort of came on both political fronts. Liberals often criticized the unfairness, the lack of due process, the potential for disparity and discrimination in the application of this treatment model. There were a number of academic studies and others that suggested that poor persons, minorities, were getting the longest sentences, and that there was a lot of chance involved if you were sort of unlucky and drew the wrong judge at the wrong time. That sort of classic TV image of the hanging judge being too much a determination of what kind of sentence you would get. And especially because this rehabilitative model was never formally a part of the federal code, if a judge decided on a particular day to be more deterrent-oriented or to sort of throw the book at them, that could happen as well. And so a number of academics in particular were complaining about the unfairness that could play out in individual cases. At the same time, sort of another force in play was rising crime rates, and you might even tap this into some of the more general social unrest of the mid to late 60s and early 70s, and particularly concerns about recidivism and repeat criminal offenders. And that led both the left and the right to conclude that this discretionary rehabilitation-based model was neither fair or effective. And so sort of a growing chorus of criticisms from every side about this problem. At around the same time, early 70s, a very influential book was written by a district court judge out of New York, Judge Marvin Frankel, and sort of capturing the idea was the title of an article that he also wrote at the same time of the book, which was Lawlessness in Sentencing. And it was a very powerful indictment, particularly of federal sentencing practices. This was a district court judge talking about his own experiences and his own sort of anecdotes about the sentencing process in federal courts, and sort of a very provocative and powerful storytelling about one defendant who would get 2 more years because he gave the judge a dirty look at the time of sentencing, or another judge who sort of decided on certain days of the week to be harsher to send a message. And both the rhetoric and the stories that Judge Frankel told very much reiterated some of the concerns the number of academics were discussing and being concerned about. There were also some other studies going on. Another one that particularly took prominence in the federal reform effort was a study out of the Second Circuit Court in New York and in the Northeast, where a hypothetical case of a bank robber was given to a panel of judges, and I think it was about 20 or 30 judges were involved. They were each given a hypothetical set of facts involving a relatively recent case involving a bank robbery, and they were each asked how they would likely arrive at a sentence for this particular defendant. And the range of sentencing that was produced in this hypothetical, some judges giving as low a sentence based on the facts of 2 years in probation, other judges imposing a sentence of up to 20 years. That study sort of gave extra credence to this notion that sentencing had gotten to the point of being a game of chance, where sort of the luck of the draw of your judge mattered more than the nature of your crime and the particulars of your offense and who you were as an offender. And drawing on all these, Judge Frankel in particular broke new ground by proposing a commission on sentencing. And his main theme, one of sort of the core of what he was saying, was we need to have some law for this process, this idea of lawlessness, in some sense suggesting it's inevitable that there would be different sentencing outcomes when judges didn't have any clear law to follow when arriving at different criminal sentences. And another important theme of what Judge Frankel was suggesting, which has sort of grown in prominence in light of some recent developments, was that having a commission sort of charged with developing this law would have the value of depoliticizing a lot of the rhetoric about crime and justice, that oftentimes this is the type of area in which politicians like to take advantage of sort of having media attention and the cameras around to perhaps propose things that wouldn't make for sound policy but would be sort of valuable in sound bites. And Judge Frankel recognized that concern. There were some experiences at the time he wrote for certain states in California and others having that dynamic in play, where the politics of crime and sentencing would lead to imperfect sentencing structures. And so he suggested this commission on sentencing, which would not only be able to be a little bit more politically insulated than Congress to create this law, but also could have expertise, could be staffed with people whose full-time job was to study sentencing developments and the criminal justice system. And so that vision of an expert body to create rules for sentencing sort of gained credence among academics, and in a variety of type workshops, proposals, some real concrete proposals developed, and the idea of a guideline system where a commission, as a specialized body, would develop a specialized set of laws which would help judges to pick sentences and be more uniform in their treatment of individual defendants. And that's where the idea of a sentencing guideline structure sort of grew out of. And primarily Senator Edward Kennedy, although with a variety of help on the Hill, introduced the sentencing reform bill in Congress. Interestingly, he introduced this in 1976 as sort of the time when a lot of this academic research and other scholarship was sort of crescendoing, but it took 8 years, the political process, which others can tell you a lot more about than I can. It wasn't until 1984 in which the Sentencing Reform Act was passed, and in many ways, a number of others have written about this history, how it only came to be passed because of the combination of certain liberals like Senator Kennedy decrying the unfairness of a system that was more chance-driven than law-driven, but also conservatives getting on board saying that we needed to rein in those soft-on-crime judges, that we needed to have a mechanism which didn't rely on the judge to pick sentences because judges couldn't be trusted. And so you brought these forces together, and that produced truly a revolution in federal sentencing in the form of the Sentencing Reform Act of 1984.
Before I give you John Steer, let me mention that as a commissioner, he is voicing his views. He is not voicing the views of the commission. And it's not to say that the commission won't adopt them, because he's undoubtedly the most persuasive member of the commission, but it's just to make clear that he can't speak on behalf of the commission. One thing I would add to what Professor Berman has said is that the Sentencing Reform Act made a number of changes from the previous law. It abolished parole. It required the judge to impose a sentence that the guidelines called for unless there was an aggravating circumstance or a mitigating circumstance that the guidelines did not adequately account for, so that the guidelines are the presumptive sentence. It authorized both parties, the government and the prosecution and the defense, to appeal an unfavorable sentencing decision. And for some folks, most importantly, it put into Title 18 of the United States Code a statement of reasons why people are being sentenced. The main thing, as Professor Berman said, was the creation of a sentencing commission. Commissioner Steer, you would please tell us about how the commission went about implementing the provisions of the Sentencing Reform Act.
Thank you, Tom. The entity that Congress created first came into being in about October of 1985, and the way Congress had set up this structure, it authorized a seven voting member body with an ex officio representative from the Attorney General and another ex officio member from the Parole Commission that has been historically the chair of the U.S. Parole Commission. Initially, those members were all appointed to full-time positions, although as it turned out in reality, because by statute 3 of the members had to be federal judges, those federal judges did not have to give up their judgeship position, and none of them did. And in fact, they chose to continue to the extent that they could, hang on to their judicial duties and carry them out with some accommodations as necessary because of the workload that was thrust upon them as members of the Sentencing Commission. I joined that first group of commissioners as a staff member in early 1986. So during the interim, there had been some work that had been done in the nature of mainly in terms of administrative things like locating office space, putting together a staff, and so forth. But the early years were somewhat hectic in that, or the early time there, because Congress had given only 18 months to accomplish what I think nearly everyone admits was a mammoth task of coming up with a comprehensive set of sentencing guidelines for more than 2,000 federal crimes. The Commission initially did a couple of things. As far as the substance of what they did, they were advised by many in academia, and the writings that had been done up to that point on sentencing philosophy and sentencing commissions and how to form a system of sentencing guidelines suggested that one of the first tasks would be to decide on a paramount or overriding philosophy of sentencing. Now, the law that Congress wrote was a fairly detailed piece of legislation, but it did not choose among the 4 stated purposes of sentencing that were expressed in the law. Congress talked about just punishment, deterrence, the need to incapacitate especially dangerous criminals, and it listed rehabilitation as a purpose of sentencing. But it did not express which of those philosophies should be the guiding one for setting up the sentencing guidelines. So the commissioners initially tried to decide that issue, and they were not very successful. When I got there in early '86, they had pretty much abandoned that initial effort. They still talked about it throughout their discussions, but they were moving on to other things that they thought would help to move the work forward. And one of those tasks that they decided that they should do and that would help them in deriving a set of sentencing guidelines was to look at state models. But there were only 2 or 3 working state models in existence at that time. Minnesota, state of Washington, state of Pennsylvania had just was in the process of coming online with a set of guidelines. So the commission studied those, but they found that the differences between federal and state law were so great that none of the state systems was entirely satisfactory to simply use as a model. So they moved on from that point to other devices, such as using the federal statutes themselves to try to see what distinctions were made by Congress within the statutes. They also decided to do a comprehensive empirical study of past sentencing practice. That was a rather Herculean task because, as our previous discussants have mentioned, judges did not have to give a statement of reasons when they were imposing sentence under the old system. But the commission devised a way, through the help of probation officers, in examining pre-sentence reports and then sending out questionnaires to the probation officers and the judges who had dealt with those pre-sentence reports to try to get them to augment them with asking specific questions about the nature of the crimes and the factors that seem to be important in sentencing. And then using multiple regression analysis with the commission had put together some researchers on staff. They were able to tell, at least for major classes of offenders, what factors seem to make a difference in determining the nature and length of sentence for particular types of crimes. All total, the commission started with about 100,000 pre-sentence reports, and they used as an augmented sample about 10,000 that covered most of the major types of crimes. As far as process, the commission, over the course of its period of formulating the initial guidelines, also tried to be a very inclusive body. They conducted a series of regional hearings. First, they conducted a series of topical hearings on particular topics like plea bargaining, criminal history, and that sort of thing in Washington. Then they moved out around the nation and did a series of regional hearings on drafts, particularly one draft that they published for comment. All total, they went through 3 or 4 drafts before they finally arrived at a set of sentencing guidelines and sent it to Congress on schedule in April 1987. The statute had provided for a 6-month congressional review period, and after some hearings on both the House and later before the Senate Judiciary Committee, and the Congress allowed that set of sentencing guidelines to take effect on November 1st, 1987.
Would it be fair to say that, for most part, the initial guidelines sought to duplicate the current sentencing practices, but in some areas the Commission made policy choices to change results?
Yes, I think that's fair. The Commission looked at the legislative history and to a certain extent the statute, but the legislative history expressed here and there a view that for particular classes of offenders, major white-collar offenders, violent offenders, Congress, or in this case the Senate Judiciary Committee writing the report, the principal report that was used, thought that sentences were too lenient. So the Commission deviated from their measure of past sentencing practice. And then in respect to past practice for controlled substance offenses, the Commission virtually abandoned it and used a different model, the mandatory minimums that Congress legislated in 1986, and I believe we'll talk a little bit more about that issue and its influence on the guideline writing process.
Okay, I'd like to pose a question now, a series of questions relating to the congressional scheme in the Sentencing Reform Act, and first relating to the goal of disparity in sentencing. Was this a serious problem, and how important is the goal of eliminating disparity if it was a problem? Anyone? Michael?
It was a problem, and Judge Frankel's book made it dramatically clear what kind of problem it was and how serious it was. But it didn't make it that clear. Because there are different ways in which cases can be disposed of in disparate fashion, there are really different kinds of disparity at work. And maybe we weren't as clear as we needed to be back then about, are we concerned when different sentences are imposed in cases which are, for example, convictions under the same statutory section? Is that what we mean by disparity? Or do we mean something closer to sentences which are random and unprincipled and unreasoned and not based on fact and are different? And there are a lot of possibilities there, and the tendency, I think, both Judge Frankel's and others, was to conceive of this as a problem when sentences differed between offenders who on some very simple criteria look the same. Because disparity, if it's treating like cases differently or different cases alike, if that's what disparity is, the crucial question is, what are the things we're going to use to define when cases are alike and when they're not? And it seems to me that wasn't so clear, and whether that was, whether we had disparity of the second kind at that time is less clear and still. That is, were the sentences imposed before the Sentencing Reform Act random, not based on fact, unprincipled and unreasoned? And I think Judge Frankel's were not. I think his sentences were not disparate in that sense.
Any other observations on that? Because I have a question. In 1976, Congress enacted the Parole Commission and Reorganization Act, shepherded through Congress by the representative from this congressional district, which changed the medical model that the federal system had been using. The federal system, up until that time, had been based upon predictions of rehabilitation. In 1976, the Parole Commission and Reorganization Act changed that to an equity dispensing system. So if I phrase the question this way, was there a serious issue about disparity in punishment? Do we get a different answer?
Well, I think your point, Tom, is that there are other mechanisms to deal with the concern about disparity, and one was sort of in place at the time the Sentencing Reform Act movement got started, which was to sort of back-end disparity concerns, that you could use a parole system to try to take care of the potential for disparate sentences being imposed at the time of conviction. And I think one way to perhaps refine the question of how bad was the disparity is to raise sort of a deeper question of, sort of in the same realm Professor Smith's suggesting, about what kind of disparity are we talking about here. I think, and there's some research to suggest that a number of judges were using the same sorts of criteria, were concerned about the same sorts of issues. If you asked a set of judges, what factors did you consider in making the sentencing determination, you'd get fairly consistent reports. They'd say the role in the offense of the offender, a variety of issues relating to the harm caused by the offense, a variety of issues relating to the background of the offender, and in some sense, there was more consistency in the approach to sentencing. But what the old system created, and what I think was a distinct problem that Congress was right to seek to remedy, was that for any individual offender, the risk of disparity, the risk of the sort of the worst kind of disparity, was always present. There was always the possibility that the sort of unlucky defendant on the unlucky day, sort of drawing the unlucky judge who was angry, mad, sad, upset that some other sentence had gone wrong in a certain way, could sort of rain terror, and this sort of cuts both ways, could rain a horrible sentence at the absolute statutory maximum for no reason particularly tied to this defendant, or conversely, could decide that this particular defendant seemed nice to them, or, as I think is probably more often the case, I don't think the discrimination that was identified was often sort of pernicious discrimination in the way we think about it. I don't think it was typically white, upper middle class male judges being extra harsh on minority, poor, socioeconomically different defendants. Rather, I think they thought they were sort of doing justice on those cases, but then kind of cutting a break to those offenders that kind of looked a little bit more like them, or particularly to the extent that Congress was concerned that white-collar offenses were being underpunished at the time, a sense that judges would be discriminatory in mercy. And I think that was an aspect of a concern here, was that there's a risk of disparity that cuts in both directions, and that was at its height in a system that had no real controls over what a judge did. I don't think if you looked over the range of cases, you'd find every sentence being unprincipled or thoughtless or even lawless, but I think you had the risk in any individual case that the extremes could weigh down on a particular defendant, and I think that's the kind of concern that calls for some sort of remedy. Whether this remedy was ideal is still subject to debate.
Well, I think there were some inadequacies of the parole system and the parole guidelines that were identified in the report of the Senate Judiciary Committee, inadequacies with regard to addressing the goal of avoiding unwarranted disparity that are important to recognize here. First, the Parole Commission obviously only had jurisdiction over a limited class of defendants who were sentenced. Defendants who were not sentenced to prison were never subject to parole consideration in the first place, and that mix of prison versus non-prison was entirely under the control of the sentencing judge. Another factor was that there was a lot of gamesmanship, if you would permit me to call it that, going on. Some judges were rather knowledgeable about the mechanics of the parole guidelines, and they would go through a process of basically, they knew what the way the guidelines worked, and they would try to outguess what the parole commission would ultimately do. They would basically say, well, I know that for this particular offender, the parole guidelines call for him to serve at least 5 years. I want him to serve more than that, so I've got to give a sentence more than 3 times as long, because he will have to serve at least a third of that. And so you can see that there was this kind of gaming that was going on. And then, of course, the fundamental second guessing was done by the parole examiner and the parole commission itself, and second guessing what the judge had done. And fundamentally, the Senate Judiciary Committee and ultimately Congress found that was an undesirable process, and it would be better to put the judge back in charge of determining what the sentence would be, subject, of course, to applying a set of rules that were to be developed and over the years modified by a sentencing commission.
Would it be fair to say that Congress addressed Professor Smith's concern about what constitutes disparity by identifying the 2 main ingredients of what it considered to be the guidelines, one being the nature and circumstances of the offense, and the other being the history and characteristics of the defendant? Didn't Congress have in mind by that what went on when the crime was committed and what's the defendant's criminal record?
I think that's right. I think the legislative history makes that pretty clear.
Is that an answer as far as you're concerned, Professor Smith?
Well, no, it's a very good one, because you have your Aunt Nellie, for example, that tax fraud of hers. Now, there's Al Capone over there, who also, first offender too, tax fraud. Now, the offense behavior, whether just the statutorily defined offense or the other offense behavior that might be taken into account in a real offense sentencing system, they look pretty much the same. The prior record looks the same. Now, maybe it's a small offense by a small person and a small sentence is appropriate. That is, the conduct doesn't deserve a prison term. That may be right. It may be that it does. But I think it would be bizarre, just bizarre, to imagine that the state's interest, the sovereign's interest in dispensing justice in those two cases could be dealt with by treating them as alike because it's the same offense and they're both first offenders.
Anyone else want to? Doug?
Well, I'd agree, and I think that's, in some sense, the challenge that Congress faced was in saying you should look at the nature of the offense and the history of the offender. I don't think they were saying only look at the criminal history. And so even though the Sentencing Reform Act is an incredibly detailed and I think sort of a majestically constructed statute, its effort to give guidance on these issues isn't going to, in and of itself, sort of end the disparity problem. And one way that I often realize this in my own mind is to say, well, let's even get real specific about what we're going to care about and what our concerns are going to be. Let's say we only want to be concerned with deterrence. And as Commissioner Steer highlighted, the Sentencing Reform Act actually lists all the purposes of sentencing. But let's imagine all we want to do was deter. And then we were to ask, well, what should either Al Capone or Aunt Nellie get just focused on the issue of deterrence? And the answer might be very different depending on which of you are judges out there. And so I think the challenge, and the challenges maybe leads into our discussion of how the Commission dealt with the Sentencing Reform Act, but the challenge was to take even a fairly specific but yet still vague statute and remedy the disparity problem, recognizing that even when you spell out what you should be concerned with, different people acting reasonably can have different conceptions of what that requires.
Let me ask the question then about what is, in the congressional scheme of things, was the role of the sentencing judge? How much freedom was the judge have in fixing sentence, and how slavishly was the judge to adhere to what the Commission said? Commissioner Steer, why don't I start with you, because that's an easy question for you.
Not so sure. Well, Congress specified in the basic structure of the guidelines that the Commission could control the width of a final sentencing range that would be available for a judge. And the statute was clear that the Commission could, if it wanted, offer no discretion, a single sentencing point, much as the sentencing laws in some of the early American colonies basically passed by the legislature prescribed a specific sentence for the crime. But at the other extreme, the statute said that the Commission could broaden that range to basically a range of 25%, the greater of 25% or 6 months. And if the sentence was over 30 years, the range could go from 30 years to life. And one of the important decisions that the Commission made was to use the maximum for every range that it created on its sentencing table. It gave the judge the maximum discretion that the statute allows. Now, I think there are some other ways where the guidelines offer discretion within the determination of various factors, so we may talk about them in a little bit. And then the statute also offered discretion to depart from the guideline range as it was ultimately determined under certain circumstances. Basically, if the court could identify an aggravating or a mitigating circumstance that was different, either in a different kind of factor or a different degree of it in which that particular factor appeared, and that factor was not adequately considered in the guideline scheme, then the court simply had to give an acceptable statement of reasons, and it could impose a different sentence. We may want to talk a little bit about the departure factors, but the Commission recognized that basic statutory scheme and in its own way tried to give it effect.
So it would be, yeah.
I have a question for you guys, because I wasn't as close as you were to the creation of this act. And I've always wondered whether those who drafted the act and provided that constriction of 25% or 6 months, whether they had done the math that would have revealed the complexity of the grid that would necessarily follow from such a, I mean, they may have, they may not have. I'm just curious. I never found out.
From my standpoint on the House side, you know, since the subcommittee I was on handled that, the answer is, at least at the staff level, yes. But keep in mind that the grid...
What were you thinking?
The grid that the Commission came up with, because of the overlap, has more ranges than are necessary to comply with the congressional statement.
I see.
And what we were thinking of was avoiding what the Justice Department wanted, which was a range of no more than 1 month at the top. So that if you think the current grid is too complex,
well,
too complicated, yeah.
That's right. We together, that was one of the early collaborations between the Sentencing Commission and the House subcommittee that Tom worked for. We were fighting against the Justice Department. We were trying to get at least 6 months of discretion at throughout the sentencing table, and the Justice Department initially strongly opposed that, but we prevailed.
So it would be a fair characterization then that judges were expected to look at the sentence the Commission had provided, evaluate it, and where appropriate, identify something that called for a different decision, and would be free to then go above or below what the Commission had recommended. The judges had a fair amount of discretion under the system, as conceived by Congress. Is that fair? Is there any objection to that?
Debatable, I would say, on that front. I mean, what's particularly interesting about, especially if you look at the evolution of guideline systems in the early days, was efforts were made to try somewhat different models. In particular, thinking about the idea of making guidelines voluntary, that rather sort of make them truly guidelines, to sort of take the collective experience of a set of judges in a jurisdiction, see how they're doing, come up with sort of maybe a statistical analysis of where most of the judges are lying, and then create sort of a voluntary mechanism to urge judges to stay within those broad parameters. And Congress in the Senate report sort of highlighted that the experience with such voluntary guideline systems were not particularly positive, that perhaps not surprisingly, each individual judge, if he or she decided that this particular offender didn't call for a guideline sentence, would say, well, I know better this time. And so the voluntary structure wasn't particularly effective in ensuring that judges stayed within the ranges that were the norm. And so I wouldn't say, and Congress explicitly said in the legislative history that they didn't want this system to be that they wanted it to be a mandatory guideline system. They wanted to ensure an opportunity to depart from that system in certain cases, but that departure authority shouldn't be so broad as to turn the guidelines into a voluntary scheme. And so I think that's why the existing federal guidelines have gotten a reputation of being very sparse in its discretionary authority left to judges, even though I'm not sure, in light of Commissioner Steers' I think accurate portrayal, that that's a particularly fair characterization. I think part of the reality that played out is federal judges went from a world in which they had complete discretion to a world in which they had much less discretion. They still had, in many ways, some discretion, but you make that transition and it's going to feel as though your hands have been tied. I don't think they often were presented with the reality that their hands could have been tied a lot more if some of the forces in play had full reign over what the guidelines ultimately look like.
Shortly after the Sentencing Reform Act, Congress enacted mandatory minimum sentences in drug cases, and for several years after added to the mandatory minimums. are mandatory minimums compatible with the guideline system that it had created in the Sentencing Reform Act? Let me start with Commissioner Steer, who has, I think, had to testify on this at one time or another on the Hill.
Well, I think that theoretically one could make an argument that the two systems are not necessarily incompatible. If members of Congress, as they voted on mandatory minimums, had full and complete information about the range of offenders and offense behaviors that would be coming before judges convicted of a particular offense for which a mandatory minimum was considered. And if they understood the details of the guideline system, then I think theoretically it would be possible to construct a mandatory minimum that would serve as a floor, an absolute floor, below which no sentence would go except under circumstances that Congress might permit. For example, they permit them today if a defendant offers substantial assistance in making more cases, helping law enforcement in fighting crime. But in reality, I don't think that is the situation that occurs. Congress legislates, intends to legislate even today when they have the advantage of much more empirical information by virtue of the sentencing guidelines, but they still tend to legislate based on the extreme case, the anecdotal case that happens in a particular member's district, and that understandably moves them to want to address in an effective manner that particular type of crime. And so they are typically thinking about the more extreme case and not the full range of cases that can happen. As a result, I think what happens is that mandatory minimums tend to be legislated for a more severe class of cases than the full range, and tend to push up sentences and interfere with factors that the guidelines recognize as being legitimate mitigating factors and have built into the calculation. For example, having a mitigating role, accepting responsibility for the offense, to name the two that are most frequently used to adjust sentences downward. So what a mandatory minimum may end up doing is blocking the use of those mitigating factors under the guidelines and treating unlike offenders in a similar manner.
Let me use that as a springboard then to consideration of the implementation by the Commission of the guidelines. Why then did the Commission adopt the congressional quantities in the mandatory minimums as the basis for its drug trafficking guidelines? You've just outlined the evils of the mandatory minimums. Why did the Commission adopt those as its own for the drug trafficking guideline?
Well, in the final analysis, I think it was a political decision, and the Commission came down somewhat in the middle. There were some, at least some members of the Commission and people who on the outside who urged that the guidelines should be written after Congress moved to establish mandatory minimums for drug trafficking. The guideline structure should start with the mandatory minimum, and mitigating factors should only bring the sentence down to the mandatory minimum. Where the Commission ultimately came down was they basically said somewhere in between. They said that a typical offender who has neither aggravating nor mitigating factors present that were recognized in the guideline structure would receive a guideline sentence that was commensurate with the mandatory minimum that Congress legislated. But it was, I think, a political judgment of what Congress would find acceptable, and it's debated even today. And I know that my current group of commissioners will, no doubt, we debate this issue, and probably will continue to debate it in the future, and it could change in the future. In hindsight, one of the things that the Commission in 1994 was able, with the help of others, to persuade the Congress to allow exceptions to the mandatory minimums in the drug trafficking statutes for what has come to be called a so-called class of safety valve defendants. Those are generally low-level, nonviolent drug offenders who at least provide some cooperation with law enforcement to the extent of identifying their full involvement in the offense and any persons involved with them. But if a defendant meets those criteria, then the mandatory minimum goes away, and the guideline system operates to provide any mitigation that might be recognized. Now, it's purely a political judgment on my part, but having been involved in representing the Commission in the negotiating the parameters of that legislation, I don't think that it would have been as likely to happen, and may not have happened, if the Commission had not adopted in the first place a structure that they could point to and say that it was basically consistent with the mandatory minimums that Congress had legislated, except that it allowed mitigating factors that most members of Congress could recognize as being appropriate ones that should allow for some lowering of the sentence in a case, in an appropriate case.
Let me read something here and ask for a comment on it. The Commission's discouragement of departures in particular, and more generally its basic approach to drafting the guidelines, were flawed at a structural level for disrespecting the judiciary's lawmaking role, just as Congress's passage of mandatory sentences denoted distrust for the Commission and the judiciary. The Commission's initial formulation of complex and purportedly complete guidelines suggested that it did not fully trust the judiciary to contribute effectively to the enterprise of sentencing lawmaking. Professor Berman, do you want to support your statement?
Oh, that can't be right.
He wrote that.
That's me. Yeah, no, I'll support that statement a lot, because one of the main themes that I think has been overlooked in a review of the Sentencing Reform Act and in its sort of early history, and I think we still are in the early period of actually sort of experimenting with that structure, is that judges have a role and should have a role not simply in deciding on the sentence that an individual defendant should get, but in a more sort of informational capacity for the entire system. Judges ought to have an opportunity, and I do think the Sentencing Reform Act meant for them to have an opportunity in sentencing lawmaking. And by that I mean that judges, through their individualized decisions, both district court judges ascribing initial sentences and appellate court judges reviewing particularly a decision to depart from the guidelines, were expected to, and in some sense should have felt an obligation to, not only achieve a just sentence in this particular case, but describe and discuss the kinds of factors that they as judges saw were either adequately or inadequately represented in the guideline structure that the Commission had put together. And the problem I've had with the way in which the Sentencing Reform Act has been implemented is that actually Congress screwed up the whole system from the get-go. And Commissioner Steer has an entirely accurate and fair discussion of the possibility for mandatory minimum sentences to be consistent with the guideline system. But I have a much simpler and straightforward answer, which is no, they can't be consistent. They are completely contrary to one another, not only in design and vision, but in how they actually come to be. As I mentioned before, one of the visions of a commission for sentencing was that it could be a depoliticized body, or at least a politically insulated body that could use its expertise and knowledge on sentencing to craft sound, sophisticated sentencing rules. The way in which most mandatory minimum sentences got passed, especially in the late 80s, I won't want to insult sort of congressional activities around this time, but the story, and it's particularly fitting during college basketball season, the story around the main set of mandatory minimums that were passed in 1986 was that a college basketball player, actually from my fine state of Maryland, Len Bias, may have remembered this story, just after he had been drafted by the Boston Celtics in the NBA draft, died of a cocaine overdose. And this was around the time that sort of the quote-unquote crack epidemic seemed to be hitting particularly inner cities around the country, but that you couldn't turn on the news and not hear about this new powerful form of drug, crack cocaine, that was sort of not only sort of wiping out and addicting populations across the country, but now had taken one of our best and brightest, Len Bias, who had seemed to be sort of a poster child for all things good, stayed in school, got his degree, finished 4 years, was going on to what looked like an illustrious career. With that frenzy, Congress passed a set of, I would say, truly draconian mandatory minimum sentences, particularly for crack cocaine, but also for powder cocaine as well. The irony, of course, turns out that, as the Commission's own documents highlighted, Len Bias didn't die of a crack overdose. It was a cocaine overdose. Nevertheless, the stories that surrounded Len Bias's death led to this sort of feeding frenzy politically to prove toughness on the drug problem. And reports from congressional halls around that time was that everyone in Congress was trying to outflank each other to seem tougher on crime, to have sort of a more powerful statement to bring home to their constituents. Look what I did. Look how tough I got. I said we shouldn't have 5 years of a mandatory minimum. We should have 10 years. That'll really show those drug users. And in my view, that's very much the antithesis of what the Commission should be about, what a development of a sophisticated sentencing guideline system should be about. And so what I was writing about there was suggesting that Congress sort of got the ball rolling in a very destructive way by initially sort of undercutting the Commission's own authority to craft sophisticated sentences, because they felt politically and understandably that they had to sort of kowtow to some extent in devising their drug sentences to what Congress had done in the mandatory minimums. In turn, I think what the Commission did was try to develop a guideline system that was at least purported to be complete in a way that didn't easily draw in federal judges to express to them and reassure them that they were going to be part and parcel of this system going forward, which I think, again, the Sentencing Reform Act had in mind. And I think this, again, relates to the reality that federal judges were coming from a perspective in which sort of they were the king and queen of the system. They got what they said ruled. They kind of knew the parole commission was in the background and was going to mess with things later, but still, in many ways, everyone had to bow to them, literally, at the sentencing hearing, and they held all the cards and worked the system. Again, often thought they were doing it in a just way. You impose this set of guidelines on them, it's understandable they're going to sort of overreact to it. And what I think the Commission didn't do a perfect job is sort of reassuring judges that they still were going to have a role to play in this system, not only in sentencing individual cases and departing, but in providing feedback and commentary to the Commission to help them revise guidelines going forward to create a more ideal system.
Well, the basic legislative history document on the Sentencing Reform Act says, and buried in a footnote, the United States Parole Commission currently sets release dates outside its guidelines in about 20% of the cases in its jurisdiction. It is anticipated that judges will impose sentences outside the sentencing guidelines at about the same rate or at possibly a somewhat lower rate, since the sentencing guidelines should contain recommendations of appropriate sentences for more detailed combinations of offense and offender characteristics than do the parole guidelines. The current data from the Commission for fiscal year 99 indicates that there were upward departures in roughly 0.5% of the cases, downward departures for substantial assistance in a little over 18.5%, which totals at 19, and then there were downward departures for other reasons in nearly 16% of the cases. Roughly 35% of the cases now are receiving downward departures. How can you say that the Commission has discouraged departures?
Well, this is post-Kuhn data, for starters, and so I was writing about a period right after the sentencing guidelines went into effect, and if you looked at the numbers in 1988, 89, 90, the number of departures, the extent to which judges thought they had authority to deviate from the guidelines, was the percentages were quite low. I think 6, 7, 8, only 8% of cases, and so that meant only 1 out of every 10 cases would a judge feel free to depart. And part of the story that I need the full article to defend is judges themselves were partially to blame. One other dynamic I think in play institutionally is while district judges would sort of, in the early days, sort of make a little effort to kind of eke out, kind of say, hey, we want to depart here. The Court of Appeals, which had sort of been a new body to sentencing, as was mentioned before in the old system, there was no really appellate review. Whatever the sentencing judge gave, there was no real opportunity to appeal to the Court of Appeals. The Sentencing Reform Act provided explicitly, especially in departure cases, an express authority to appeal a departure by both the government and the defendant, depending on which way the departure went. And a lot of the Court of Appeals judges sort of came to their enterprise as, well, we're in charge of making sure this guideline system works. We're in charge of making sure these trial judges don't leave the guidelines behind too often. And so part of the dynamic that was in play was the courts of appeals were fairly stringent also in allowing departure authority to go forward, and I think in some sense aggravated the commission's message that, hey, you shouldn't really depart very much. It's not part of your role in this system to take off from the guidelines too much. And actually a variety of academic commentaries and other expressions of concerns by federal judges themselves led to, in 1996, the Supreme Court saying, in an interesting vehicle for the case, the Rodney King case, actually the sentencing of the Los Angeles police officers who were ultimately convicted in federal court and sentenced under the federal sentencing guidelines. The Supreme Court used that case to announce that the courts of appeals ought to be more deferential when they reviewed the decisions by district courts to depart. And so a big part of the modern story of how the guidelines are being applied is that case really did, and it's still sort of rippling through the courts, sent a signal to the courts of appeals to kind of lay off a little bit. Don't rein in the district judges when they want to depart. And so we're seeing, Commissioner Sear can document it probably more clearly than I can, that the numbers of departures have risen almost exponentially after the Kuhn decision. And for other sorts of complicated reasons, in a different article I've expressed, I'm not sure that's a great trend, but I think it suggests that the discretionary authority that exists in the system is getting broader and expanding as the system evolves.
So let me just try and cast a less favorable light on those matters. If I'm listening to and now looking at the data that you were reading, it looks to me that the substantial majority of downward departures, 20% of cases, are downward departures for substantial assistance to law enforcement. Now, I wanted to point that out for a couple of reasons. I mean, one is that that's a departure which is wholly within the control of the prosecutor, not the judge. Okay? And as I remember, the extent of that departure is not restrained by the guideline system. Now, so I want to raise that for obviously another reason, which is I want to go back to where we started with this. How can it be that disparity is the problem that's been cured when one fact about a defendant, an offender, a post-conviction fact to be sure, is going to make that much difference when there are lots of other facts that seem to me might merit attention because of the benefits they bestow upon even law enforcement that are not available? And so it looks to me like this is, if nothing else, substantial evidence of a serious disparity problem within the federal sentencing guideline system.
Commissioner Steer, you've testified on the Hill about this issue, if I'm not mistaken, rather recently.
I knew he's prepared for this.
Yes, so what's your response? Or what is Congress interested in, and what concern was expressed? And B, what is your response to Professor Smith?
Well, I'm in substantial agreement with the concern that Professor Smith has articulated. I think that this certainly has the potential to undermine, to a great extent, one of the goals that Congress articulated, and it's worse than simply saying 20% of the cases are receiving a sentence outside and below the guideline structure and is in an unregulated sentence. If you look at the variation in that percent of downward departures for substantial assistance among districts and circuits, it varies widely. There are districts where almost half the cases are resolved in that manner. There are other districts in which 5%, give or take a few, are resolved in that manner.
Is there any district where more than half are resolved in that manner?
I don't think the last data showed more than 50%. But
I'm a quarter off then.
yeah. But Eastern District of Pennsylvania, Philadelphia area, and Western North Carolina, and some others have been right in the 40s consistently, and that reflects, a sentencing pattern that's become fairly ingrained, and as he points out, it's in the control of the prosecutor. So I have been, fairly critical of the lack of regulation from the Justice Department of field prosecutors, the lack of standards, the lack of any attempt on the part of the Justice Department to meaningfully regulate that. At the same time, I guess that I do agree with the fundamental decision that Congress made to allow this as this means as a downward adjustment for sentence. It has I think, a worthy law enforcement purpose, and I agree that prosecutors should be in control. I just want some standards to be evident here. I think that the Commission perhaps has a role to play in regulating, if it ever wanted to, it was ever willing to, the manner in which judicial discretion is exercised once the prosecutor opens the door. Right now there are no standards, no expressions of policy guidance, even in a voluntary manner, nothing at all that tells the judge how much a particular type of assistance that is recognized by the prosecutor should be worth. Is it worth a 25% discount or 50% discount? I think through studying the case data, the Commission could provide some meaningful guidance, because many judges don't know. They are looking for guidance, and we've provided them none. But I must say that while this is my opinion, I serve with others who don't necessarily share that view and are not particularly moved to regulate in this area where now judges, once the door is opened, enjoy absolute discretion.
Like a good litigator, I'm going to use your facts to support my argument, which is to suggest that this data shows, and it's part of the broader lesson we're taking from this, that regulating sentencing is a hydraulic system, and an effort to regulate discretion in any one arena is necessarily going to have an effect on the exercise of discretion in others. And I actually look at a lot of the data on the wide use of these substantial assistance departures, and really what they are is an effort to give prosecutors a power to give an incentive to people to rat out. And that makes some sense for a variety of criminal justice reasons, but I think the failure of judges to feel as though they had the power to do justice through departures for other sets of reasons in many ways fueled an interest in some prosecutors to use that power to do other ends. And so, in fact, there's some data to suggest that when the Kuhn decision came out and it gave judges a little bit more authority to depart, or seemed to, and judges felt like they could, you'd see the number of other kinds of departures rise and the number of substantial assistance departures in the same district lower. So that you end up getting the same cumulative rate of departures, and in many ways that's supported my instinct that a number of the actors involved in an individual case have a collective vision of the right just result, and there was a tendency before judges felt and recognized the authority they had to depart to sort of let the prosecutor do a lot of that work. And so, again, I think it raises some disparity concerns. It raises some worries about the ways prosecutors are using that authority. And again, that highlights that even as you try to regulate judicial discretion, that's not the only discretion in the system. You got to watch out for what the prosecutorial discretion involves. And We've gotten rid of parole discretion, but as we've discovered, there's always pardon discretion in others that can, again, sort of kick in and cause results that we may not think are entirely equitable.
For those of you who are interested, these are the guidelines that we're talking about.
How long can you hold that?
They are now, over the course of the years, roughly 615 separate amendments. Some of those amendments very short and simple, some a little more complex. 95% of the defendants in the federal system, almost 95%, currently plead guilty, and for them the only issue comes out of this book. There are sentencing appeals, and the only issue in those appeals is a sentencing matter, and it may happen, and it frequently does, that the person goes to trial, loses, and the only issues preserved for appeal are sentencing issues. The guidelines have been criticized for being overly complex, requiring a lot of fine line drawing for 2 points here, 2 points there, backbreaking minutia, which in the end may be washed out by a substantial assistance motion, for example. Is the complaint about the guidelines being too complex a fair complaint? We'll start at the far right from the audience's point of view and move in this direction. Commissioner Steer?
Can I stop and tell a joke? It's relevant.
Yes.
Well, it seems that there was this federal judge who was taking a walk along the beach and contemplating what sentence to impose under the guidelines in the next case that he had coming up. And he came upon a bottle, picked up the bottle, rubbed it off to read the label, and out popped this genie. The genie said to the judge, I recognize that you are a federal judge by your demeanor. It's perfectly obvious, and I'm here to grant you one wish. I am only a one-wish genie. What would you wish for? And the judge thought a little bit, and he said, well, you know, the next meeting of my circuit judicial conference is in Hawaii, and I would really like to go, but I must confess I have this horrible fear of flying, and I have resolved that I can't go, but I wonder, is there any way that you could construct a bridge from the West Coast to Hawaii, and then I could drive and I could attend my judicial conference meeting? And the judge said, the genie said, well, Your Honor, I mean, golly bum, can you just think of the work that would be involved? All that steel and concrete, have to drive pilings, thousands, maybe even miles deep in locations. Isn't there something else that you could wish for? And the judge said, well, you know, I do really struggle with the complexity of these federal sentencing guidelines. Could you possibly make them a little simpler for me so that I could understand them and do justice? The genie said, Judge, you want that highway 2 lanes of 4. So are the guidelines overly complex? I would readily admit that they are certainly, compared to the state models that are extant today, they are far more complex. They are a detailed system in part, however, because I think the statute, and particularly the legislative history, indicated that Congress wanted a detailed set of guidelines. The legislative history indicated that Congress wanted individualization of sentences, but they didn't want it achieved just by departing from the guidelines. They wanted it to be done by the guideline system itself. So, i.e., they wanted the guidelines to take into account a lot of the meaningful factors with respect to the offense conduct and the prior criminal conduct. And Congress has added to that over the years, most recently, in the more recent years, by directing the Sentencing Commission to make various changes in particular parts of the guidelines to add, in many cases, new factors. In fact, much of what, since I was appointed to the commission and my colleagues with me and our commission reconstituted in November of 1999, our first 2 years of work, many of the amendments we have made have been to catch up with a backlog of legislation that Congress had enacted, and that legislation in many cases contained specific direction from Congress of how they wanted particular guidelines to be rewritten in response, in many cases, to amendments in criminal statutes. So I don't want to put off all the decision-making and blame it on Congress. That would be inaccurate. The commission, past commissions made basic decisions that led to the structure and to the extent that it is somewhat complex. But certainly that trend has been exacerbated by what Congress has seemed to want in recent years.
I might be out of a job if they weren't so complex, so I don't think they're too complex at all. Seriously, I think the notion that you can do this and do this well and keep that book really thin is misguided in some sense, that the more you want to do, the more ambitious you are in trying to regulate discretion. And in some ways, the more sensitive you want to be in order to ensure discretion is well exercised. You make that book longer. And in some sense, that's particularly the challenge these days. We were talking before about one area of the guidelines that's very short, and that relates to the substantial assistance power. That's just sort of essentially one page with an additional sort of page of commentary to it. It could be on a single double-sided page, the entire discussion of something that affects 20% of the guideline sentences. And if, after looking at it, you decide, well, gee, that's too much unregulated discretion, we need to do something here, well, that's going to take 5 or 6 pages at least, and then an additional level of complexity comes into play in asking whether that applies retroactively or, maybe some law students go into the law library and say, this is much too complex, look at all these books here, but I don't think the size and scope and challenges that trying to do this well inherently mean that a big book means it's too complex. I do think the Commission, and sometimes pushed by Congress, decided to get precise in strange ways. Particularly the criminal history components of the guidelines are sort of understandably intricate for the concern about trying to deal with the range of different kinds of criminal histories that offenders have. Again, a lot of the offenders in the federal system come from different state systems, and Wisconsin may use an entirely different model than Ohio, the state I come from, in deciding how even to define different kinds of criminal sentences and criminal paths. And the Commission, I think, tried to be very sensitive to all those dynamics, but the result was a chapter describing criminal history that, when I decide to be real cruel, I make my students read. And so I think the complexity criticism in theory is not a good one, because I think it's an inherently complex task. I think when you get to look at particular sections, you can rightly say, gee, there's got to be a somewhat easier way, but I'm not sure the easier way leads to a smaller book. It just leads to one where it's less addition, subtraction, and more guidance through a variety of sort of discussions of sample cases and things like that.
Well, it's so I want to make a complicated point, and I don't have as much opportunity as the Commission does. There's room for it, because it seems to me that it's too complex, but because it's complex about the wrong things. I mean, its very complexity is in part because the effort here is to reduce the relevant facts to 2. But to accommodate all this other stuff. So you have complexity, which is tedious to read, partly because it seems so irrelevant, right? Now, I want to suggest a reason for that. It goes all the way back to this reluctance at the beginning of time, and perhaps a conceptual failure at the beginning of time on this question of what's the purpose of the activity in the first place. Because it's all well and good to say we don't need to, which is what the Commission said, we don't need to select among the purposes that the Congress mentioned as being appropriate and desirable purposes of sentencing, because whatever sentences are imposed will likely serve all of them. Now, that's just patently not true. And it's not true because offenders and offenses vary so very much in their circumstances and characteristics that unless your only purpose is to conform the pain delivered to the statutory definition of the crime, well, it's a complicated matter. And it's complicated precisely because the individual facts of the cases and their circumstances matter when you're talking about purposes. But worse, the conceptual problem. Rehabilitation, deterrence, and incapacitation are not purposes of sentencing. They're strategies, perhaps, for accomplishing a purpose, which might be the reduction of crime or the increase in the safety of our lives. Retribution is a purpose, I grant you. That is, delivering a consequence that's deserved for the conduct that's under examination. That's a purpose. But it doesn't make sense. It's apples and oranges to have retribution, incapacitation, deterrence in the same breath. And so that conceptual problem leads to enormous complexity. A different kind of complexity is required because the subject matter and the activity and what's at stake is so very great, right? So you have to have complexity, but that's the wrong complexity.
Let's take some questions from the audience at this time. If you have a question, raise your hand, and I'll be out with the microphone so you can be heard by all and yes, and get on camera. Are there questions? Is anyone awake?
I just have a question for the last speaker. If that's the wrong kind of complexity, what's your suggestion as to the right kind of complexity?
Well, my suggestion is it would obviously take a little more space than I've got right here. I wouldn't take that much space, maybe. But let me try and sketch its dimensions. It's too abstract for comfort. But, I mean, I think, just go back to his Aunt Nellie and Al Capone. I mean, it seems to me that some specification in a case of what it is that the state interest, what's the state interest to be pursued through the use of the state's penal power, is a necessity if we're going to have law applied here and get results that are reasoned from fact. Aggregate sentencing, right, doesn't permit that. So the complexity that I seek is fact-finding so to support reasoning for instruments suitable to purpose. I want sentences to be plausibly related to the public safety purpose and to the delivery of a just punishment purpose. Now, I can say a lot about all that, but it's quite abstract, and without the ability to read and underline and sort of go back and ask more questions, I don't think it's too useful for me at this point in this day to try and lay it all out. But after, right, we'll have a long talk.
Other questions?
It strikes me as I listen to you talk about the substantial assistance departures that over time, regardless of type of sentencing structure, advisory, presumptive, mandatory, departures are gravitating toward approaching a regression toward the mean. And this is just a comment. I am certainly not on top of the data most current. My data is about 3 years old. I would find that a fascinating, serious research project. It seems to me what we're seeing here then is a phenomenon that matches what we know about sampling and populations. And the difference between the types of sentencing structure is mattering less the longer these systems are in place. I guess that's a comment and a suggestion for when you get your research department back going. You could look at it.
Other questions or comments?
this question may be born in ignorance, so just correct me if I'm wrong about it, but it seems that many of the federal offenses, as well as other places, you don't usually come in with one count. You come in with multiple counts. And if it's drug offenses, you come in with 5 or 10 counts because there's all these times. And the federal sentencing guidelines are great about giving you a guideline range of 200 months or some kind of thing like that. But unless I'm wrong, I'm not aware of a lot of guidance on whether those should be, how those should be run. If you have 10 sentences, you could have 10 concurrent sentences ending up with a 200-month sentence, or you can have 10 times that, 2,000 or whatever it is, years. And doesn't that just make the guidelines almost meaningless?
Well, actually, there is a guideline that addresses whether the sentences on multiple counts should be run consecutively or concurrently. That was one of the challenges that this particular commission, speaking of the initial group of commissioners, undertook, and I think it's fair to say that it was directed by statute that most state systems, as I understand it, do leave completely up in the air. But under our system, basically there is a guideline that addresses consecutive or concurrent, and it provides for incrementally consecutive sentences for multiple counts of conduct. In the case of quantity-driven offenses, drugs, frauds, and so forth, the aggregate sentence is achieved, first of all, by looking at it as a composite offense, and then the direction in the guideline that deals with consecutive or concurrent basically tells the judge to achieve the aggregate sentence that the guidelines call for by imposing that sentence, if possible, on the first count, and then running the sentence on all the other counts concurrently. If it's not possible to achieve the guidelines, what the guidelines call for in terms of an aggregate sentence in that fashion, then the court should do it by imposing consecutive sentences to the extent necessary to achieve an aggregate sentence.
Further questions at this point?
This may be more of a comment, but what bothers me in most of the discussions about the guidelines is the attention and concern that is paid to disparity in sentencing by judges, which strikes me as the smallest part of the problem and also the most obvious and public part. You have a system, a criminal law system, in which legislatures decide what crimes are important, what kinds of conduct should be made criminal. Huge discretion among legislatures to make those kinds of decisions. You pass laws, crack cocaine, powder cocaine, whatever. You send law enforcement people out into the field to enforce these. They're going to enforce them more heavily in certain areas where it's easier to pick up people. They may enforce cocaine laws this year. Next year they'll get a directive from their superiors. This year we're going after gun laws. This year we're going after spousal abuse, whatever. The person who's actually arrested, who doesn't rat on his friends and get released, who decides to gets prosecuted, the prosecutor decides, we'll sentence you with a telephone fraud, or we'll prosecute you for 7 million grams of cocaine or whatever, has huge discretion that no one in the newspaper business knows about, no one on television knows about that level of discretion. This person finally gets to court, pleads guilty, goes to trial, whatever, and then with this little amount of discretion left in the system, the judge is the one who gets all this attention and concern and all this huge amount of money that's being spent to restrict the discretion of the actor in the system that has the least discretion. It strikes me as that old joke about the guy who's down on his hands and knees under the light post, and someone comes along and says, "What are you doing?" And he says, I dropped some money and I'm looking for it. And the guy said, "Well, let me help you. Where did you drop it?" And he said, "Well, I dropped it over by the street, but it's easier to look for it where the lights are." And that's what I think we're doing. We're worrying about discretion, disparity, at the level where there is the least disparity and discretion. And I think it's really strange.
I think you're really right.
And I think that, that's exactly the sort of biggest struggle with this entire enterprise is, well, given the reality that there are all these other discretionary actors, and in fact, one you left out, I mention this to my students all the time, and they don't think about it because I think of the whole world through the sentencing lens, but it's really victims, in many ways, have the most sentencing discretion. If I, get my whatever stolen and I decide not to report that to the police, well, whoever did that doesn't get sentenced at all. And, and even in a more formal way, depending on how a variety of different victims communicate to legislatures or to sentencing commissions sometimes, or to particular prosecutors in particular cases, that can have a profound influence on how the system proceeds forward. And I think in particular, prosecutorial discretion is an area that you focused on, and rightly so, as somewhat more visible, maybe that area kind of next to the light, which we can kind of see just enough to realize how ugly it is, or at least those who look at this closely, but not enough to feel comfortable about how to regulate it effectively. And I guess the challenge is, well, given that there's all this other discretion in the system, and I think at some level the recognition that we can't control that too much, or another good example is to recognize we've tried in other ways with oftentimes very disconcerting effects with respect to victims. There's a whole story about mandatory prosecution laws in the context of domestic violence and requiring whenever there's a report at all about domestic violence that the police pursue it a certain way, the prosecutors go forward with that way. I think it was it Minnesota recently, not too long ago, Warren Moon, I think of Minnesota just because he was playing for them, but got sort of wrapped up in what everybody sort of involved said, this is a crazy prosecution, we don't want it to go forward anymore, but an effort to regulate discretion at that level produced, again, a different, strange sort of ripple effect throughout the rest of the system. And I think you're absolutely right that we've focused on judges in many ways because it's not only the most identifiable, but it seems an easiest area in which we can feel like we're doing something. And I'm not so sure whether that means we shouldn't be or should continue what we've learned from this experience and say, well, how can we apply some of these dynamics to prosecutorial discretion? And how can we take some of these dynamics to jury discretion, you might say? We do that in the capital sentencing context as well. And that's one of my hopes for this entire system, is that we learn not only about the realities of trying to regulate judicial decisions and sentencing, but learn more broadly about the benefits and burdens that come with any effort to regulate discretion in what I like to describe as this sort of hydraulic system, and see if we can take from that the kind of insights we need to hopefully create some effective control of discretion in other places that we see it causing problems.
From my vantage point, of course, the Commission takes as a given the law as enacted in the mission that Congress has given us, which does focus on primarily on the regulation of judicial sentencing discretion. But even within those more limited parameters, there are decisions that have been made by the Commission that tend to, an extent at least, mitigate the effects of prosecutorial decisions and to an extent preserve the ability of the judge to look at the totality of the relevant offense conduct. But some of those decisions that the Commission has made are controversial in their own right for different reasons. I'll mention just a couple of the devices. Relevant conduct is one of the more important devices that the guidelines use, where the focus is not just on the offense of conviction, but what at least for guideline purposes, the guidelines consider to be the totality of the relevant offense conduct, which may include, for certain types of offenses, in fact, for most offenses in the federal system, may potentially include uncharged conduct, charged and dismissed conduct, even in the discretion of the judge, sometimes acquitted conduct. All of those are very controversial, but it's a device to basically say that the judge should be able to look at the entire offense conduct picture, even if the prosecution has exercised its discretion to narrow the focus more. Another device in the same direction that was mentioned in passing, I think cross-references from one guideline to another there, even though the prosecutor may have elected for good reasons or perhaps not so good to allow a charge bargain to what is called a telephone count in a drug trafficking offense scenario. The guidelines do have a cross-reference that will go back to the drug trafficking guideline and look at the totality of the relevant conduct within the bounds of the statutory maximum that the prosecutor has agreed to as part of the plea bargain. But again, those devices have controversial points about them in their own right. We do what we can within those parameters.
Other questions?
I'm wondering if any of you think that the need to limit discretion on the part of judges, at least in the federal system, would in any way be limited some if judges were subject to the will of the electorate. Do you think that's in part individuals believe that judges should have some of their discretion removed simply because they do have life appointments?
It's up for grabs, whoever wants that.
That scares me, only because that suggests politicizing that decision. I mean, one thing that I think we've seen in some state systems that I do some work also on death penalty cases, and that's where there's a lot of literature about how a number of sentencing judges involved in death penalty trials feel compelled when they're up for an election cycle to make sure this goes down the way the people are likely to want it. And the reality of crime policymaking is sound bites work, and you rarely see a commercial that, yeah, this judge did a nice, just, fair sentence and let a guy off. No, it's, they let this murderer walk free and did this and that and these and those. And so I'd be concerned. I like the vision of some other controls over discretion, and whether there are other mechanisms to do that, I think is something worth exploring. My concern in the history of crime and justice policymaking is overtly political controls don't seem to be ones that are anything but a one-way ratchet towards harsher sentences and sort of a more aggravated approach to crime and sentencing policy. Now, I think that's changing potentially, and I think we see experiences, especially a fascinating, I think, underreported component of this past election cycle, perhaps not surprising given the other parts to report about, but California recently passed through a voter initiative a requirement that first and second time drug offenders get treatment before getting sentencing. And that, I think, suggests that we may be coming to a tipping point where the crime justice rhetoric is not always pushing towards harsher sentences. And if we get to that point, maybe I'd be a little more open to the idea of sort of an election cycle approach to controlling discretion. But at least the past 15, 20 years suggests to me that takes us away from sound policy making and towards soundbite policy making.
The thing that bothers me most about these regulations is that, we have a system which is dedicated to the proposition of freedom and human dignity. And I did a lot of trial work, and I did a lot of defense work. And what you're doing is you're neutering. Now, maybe what you say in that courtroom, the court may not listen to. But the fact is that the human being you're representing will listen to it. And he will hear someone saying, something decent about him, and have consideration for what should happen to him. And when you have these kind of rules, in my judgment, you're taking the human aspect out of that courtroom. But it is a human aspect. It's an individual who's in there to be looked at and treated. And my friend Steve Hurley, I know he's frustrated. He's a criminal defense lawyer and a very responsible. But he's frustrated because he's toothless when it comes to attempting to persuade a court that there's some decency in the human being that he's representing.
For Commissioner Steer, let me phrase the question this way. Don't the guidelines tend to type the individuals rather than as human beings with feelings and aspirations and hopes and desires as a criminal history category 1 offense level 32? Is there a dehumanization in the guidelines?
Well, I suppose one can look at it that way, but I'm not prepared to accept the proposition that the alternative necessarily leads to better justice. Our federal judges, I think, are an outstanding group, and I have had the privilege of teaching federal judges about the guidelines for quite a number of years. We have what's often called baby judges school for the newly appointed judges, and they get almost a week's worth of instruction about sentencing procedures and the sentencing guidelines and so forth. And what I have been struck by is that those who are appointed to the federal bench, while they are outstanding lawyers, are not necessarily individuals who come to the task with any particular background or knowledge of what to do when it comes to sentencing an individual, of how to recognize and weigh and give appropriate weight to these factors that we're talking about that relate to the humanity of an individual. Now, that may be a meaningful concept for an experienced judge who has had years of imposing sentence, but I don't think it means much to a newly appointed judge who comes into the federal system with a civil law background, or even some of those who are appointed with more limited background. What these judges, what the newly appointed judges are good at, without a doubt, I think, is applying a set of rules to a set of facts, and then within a range, exercising some discretion, and then perhaps making a decision as to whether or not the case is atypical and should be sentenced outside that range. That's what they do in other contexts. That's what judges are best at, I think, is basically applying a set of law to a set of facts.
Let me argue with you.
Why should sentencing be any different? Now, you go ahead, Professor Smith.
Well, because it seems to me it's a somewhat impoverished way of describing what judges are good at. To put it, to sloganize it a little bit, Frankel called for the rule of law in sentencing. What we've got is a law of rules for sentencing. And not at all the same thing. It seems to me judges are very good at finding facts and applying facts to law and reasoning to conclusions which are required of the court under a certain jurisdictional definition. That's stuff that judges do very, very well. But to say that they're particularly good at taking a set of rules, just rules, and without regard to the purpose of them, without regard to the variation of facts that are outside the rule boundary that's set by the rule maker, and applying them to get just results strikes me as diminishing of good lawyers. It's not what they're good at. They're good at reasoning and fact-finding.
Well, where does the judge... Oh, excuse me. Your turn.
I was going to chime in with the moderate position, which suggests that well-functioning guidelines can strike that balance that we're seeing here at these extremes particularly effectively. The problem... Well, I had to be too extreme, right. The problem with the system that's entirely based on humanity is it becomes a system based on who can represent through a skilled advocate who seems most human that day in the courtroom. And I think that's, again, a system that's fraught with as many risks as it is with potential, and
I agree with that,
particularly in light of the reality that it's dangerously easy for judges, if it's a question of judging humanity, to give it short shrift. You know, well, I can sort of tell what they look like, and I'll read the pre-sentence report and get sort of a flavor of that, and I think it's dangerously easy, particularly that it becomes that judges humanity. And the reality is, and I think maybe that's even part of the unspoken experience of Commissioner Steer, the reality is the humanity that the average federal criminal defendant experiences is entirely different than the humanity that the average federal trial judge, sentencing judge, knows about. And that, again, in my view, doesn't necessarily demand disparity, but creates a risk of disparity. At the same time, I think you risk, if you focus on creating a regimen of rules, that you leave that piece of it out. And again, I love to rehabilitate the Sentencing Reform Act. I think there's a lot more humanity in that piece of legislation, and there's a lot more humanity in the guidelines than they're given credit for, and that lawyers even realize. The problem, again, I would say, is partially the Congress's fault in not stressing those important points, and partially the Commission's fault for not reiterating to judges that they're supposed to be factoring in humanistic type concerns when deciding where within the sentencing range to go, when deciding about a departure, when maybe even deciding how to apply certain controversial components or particularized components. I mean, one of my favorite versions, everyone would agree, and the Commission reflects it well in the guidelines, that a defendant's role in the offense should be a significant factor in sentencing. You know, whether you're the leader or the organizer, it can be an aggravating matter. And so the Commission's guidelines has a calculation for that. Similarly, if you're just a minor or minimal participant, I'm using the guidelines' exact language, that's a mitigating factor if you're just a sort of a bit player, the drug mule, someone slightly involved. Well, not only is that a significant factor to think about in terms of terminology, gee, were you a leader or an organizer or a manager or just a minor participant or a minimal participant, but I think that's a humanistic question as well. It's not just affixing a label. What's a minor participant versus what's a minimal participant, but I think it can be a more holistic inquiry about what led this particular defendant to this position in a criminal enterprise that in turn produced a certain unfortunate criminal dynamic. And yet, I won't fault the Commission too much, they don't stress those humanistic components. Rather, they write a set of rules which say, well, here's what defines what a minimal participant is. And I'll throw the Courts of Appeals judges in too. They then come up with their own complicated law-like rules to figure that out as well. And in some sense, I think it's the inevitable reality that lawyers are more comfortable with law and rules than they are with humanity in ways that leads you to a system that seems less humanistic than it might otherwise be if everybody, while they were doing it, kept reminding themselves, hey, we're doing an important human enterprise here.
I guess I have the mic for the moment. I'm glad you mentioned Congress as you did a few minutes ago, because in my assessment, that's the legislative, that's the branch of government that's driving the train here, and they're as big a check on the power of the prosecution in this regard as they are on the judiciary. But I wanted to respond to what comment Mr. Cates made a few minutes ago, and I agree with him that the guidelines in some sense seemingly take a bit of humanity, or perhaps, depending upon where you sit, a lot of humanity out of the sentencing process. But I disagree with the suggestion or position that that the guidelines disempower the defense bar. I think that the guidelines have made the role of the defense attorney far more significant in the sentencing process than it ever was before. And if you bear with me, I had a brief anecdote. My days as a former prosecutor, after the guidelines had been in place for a couple of years, I had a chance to sit down with a defense attorney and work out a plea agreement in a pre-guidelines case. And he came into my office, and we looked at each other for a couple seconds and said, how did we used to do this? And we never really did. It was, well, we're going to demand 2 felony counts, and you can go in and make your rhetorical pitch, and I'll go in and make my rhetorical pitch, and we'll throw it to the judge. and the sentence will be somewhere between 0 and 10 or 0 and 20. And now there is much more back and forth, negotiation, examination of the facts, and not just rote application of the guidelines, but I think resort to the commentary and resort to case law to see how the particular circumstances of this case have been applied before, what the commission intended through a particular guideline, what did they mean, and of course there's far more appeals than there ever were in pre-guideline days, which results in closer examination of the sentence that's been imposed.
Were the guidelines and standards of other countries considered in developing these guidelines?
Well, I don't think that there was much to consider in terms of anything like the system that was asked to be developed. Commissioners, I think, did get some information of what Canada had done, as I recall, but I think there was a paucity of information there.
I'm speaking as an admitted student, but I also happen to write pre-sentence reports for the state. We look at different things such as prior record and family background, which is talking about the humanity, remorse of the victim, especially in sexual offense cases, the victim's wishes, especially in DV cases, domestic violence cases. Recidivism, even so specific, we look at things like what kind of a sex offense for example, an incest offender isn't likely to recidivate versus a lewd and lascivious behavior type of offender. And then the other side of the coin too is availability of local programming. Perhaps is a lot of people would argue is a lot different in Milwaukee County than Dane County, and the sentences are reflected in that. So my question is, what factors do the guidelines take into account at the federal level in recommending the proper sentence, and what is the goal of sentencing in 3 words or less?
The goal in 3 words or less ought to be, well, no, it's 6 words, damn it.
Crime control.
Professor Berman?
If we're talking about a sexual offense, first of all, let's understand that in the federal system, those offenses are typically prosecuted at the state level, and we do have guidelines for those offenses, but they are used primarily for offenses that happen within the limitations of federal jurisdiction, and that, as it so happens, turns out to be very heavily Native American populations. What we consider are things such as what type of sex offense. Are we talking about statutory rape? Are we talking about rape? Was it done forcibly? Was a weapon present? Was the victim injured? We're considering adding an incest enhancement in this amendment cycle to the guideline. That's sort of a picture of the basic guideline structure. We look at whether or not the defendant accepted responsibility. These offenses don't typically involve multiple players. They could, but so rolling the offense is not likely to be an adjustment here. There may be multiple counts. That's taken into consideration in the federal guidelines. We look at criminal history, and the criminal history is scored through, as was described, a fairly complex system. That those offense and prior criminal history factors together would determine a guideline range under the structure that we have in the federal system.
Yes. Well, I would like to say that for me, the insight that I have gathered today from this is very interesting, and the reason why I ask for this is because, well, you know, you all of you are persons that could do something, you know, could have the power to speak and be heard, and what you think, it's important because what you think is you have the means to do something for most of the citizens. And since you are in that position, I would like to share two things that I have experienced. I have been practicing law for 6 years, all criminal law. I practice law for legal aid, 1 year. And first of all, I would like to say to Mr. Smith that what you said, that the problem is too complex, and that's not the mean. For somebody to understand that, that person, well, you see, what happened here is that crime has nothing to do with punishment, at least in my opinion. And you spend all this time and all this money working on the punishment, and the punishment has nothing to do with crime. Because if you have a crack addict, and you could tell him that if the next time he go and use crack, he will go to death. I mean, you kill him, he would do it, because that's not the thing. You know, punishment, is, at least in my experience, has nothing to do with crime. And that's one thing that I believe, that if you spend all this time and all this money working on what could be done to stop those people to commit the crime, would be much better for the whole society. But then you have another problem. These guidelines, which I have been working with them for a year only, since they convinced me that I should go and work at the federal level. The problem with that is that you have thrown so many variables that need a subjective analysis. And if you see, every human being is different. That's why you have judges that see the same problem and will come up with different results. Because the truth is, we are all the result of our background and our values. And if you try to make that, I mean, here you have a mathematical equations with a lot of variables that are subject to our own opinions. And that makes it even more difficult for the judges, because now you are throwing to them a lot of variables that they will have to, for each one of them, pass their judgment, which I think makes it even more difficult. But what makes this even more difficult is the problem that the practical problem with the courts. Now the judge sometimes are brought, I mean, let's put it this way. Somebody plead guilty, and that guy, the person in charge of the pre-sentence report, start working on that. And he comes up with some findings. But those findings, the lawyer do not agree with what they say. So now we have a mini trial trying to see if those things should be taken into consideration, when you're going to sentence that person, which is very, very complicated, you know. So I think that and I'm sorry, but that's just my opinion, the guidelines, even though the purpose maybe was in good faith, has brought to many lawyers and a very, very difficult problem that usually reflects on your client, which is the one that eventually will go to jail. And another thing that I would like to mention, just to finish, is that what is happening here is that the way the guidelines are created has taken the trial lawyer most of the time out of his job, because sometimes it's more important what kind of relationship you have with the prosecution, because the guidelines help your client if you provide that kind of information and if you cooperate with the prosecutor. So I honestly believe that that's not an answer to the problem that we have, because well, I could be speaking for hours about that, you know, but honestly hasn't. And the last thing is that I think all of you would agree that still disparity. So the objective which you start, you didn't reach it. Well, at least that's why I think.
Let's make sure it's true. Do you all agree that there still is disparity?
Yeah, I agree. But, you know, all that, I really want to say something, right? We're all making statements now. Is it time to make statements? It seems to me something that's not obvious at first. You know, you talk about, I mean, what's the experience of your average sentencing guidelines commissioner in sentencing people, particularly in sentencing people who aren't there? Right? Now, it wouldn't have occurred to me except for this. In the very brief period when people didn't realize how little affection I had for guidelines, they put me on one of these sentencing guidelines committees. And, you know, I'm a lawyer, and I like to solve problems, and we solved a lot of problems, and we got ourselves a grid. You know, we did all the research, and we got all the regression analysis, and we got all these numbers, and we put all these numbers into that grid, and we had all these rules. The first day we sat down with the numbers on the paper, went around the room, and everybody in that room found a number that was too low. And so we raised all the numbers. And then after about an hour and a half, 2 hours, I said, I'd like to move for adjournment until tomorrow. I just think we need to go outside. I said, we just sentenced 275,000 people, right? If you think about the duration of these likely guidelines and who's going to come through, and the number of years of imprisonment that we've just imposed, and we don't even have a pre-sentence report. What are we doing? And it scared me, you know? So, I say, what experience did I have for participating in that? I didn't raise a number. I was the only one. But I tell you, it was a scary thing. It was a scary thing.
Well, I mean, I'll respond to that comment and that one as well. First, I think a lot of what you say is awfully true, but in criticizing the guidelines, it seems as though you're shooting the messenger. I mean, in many ways, a lot of your concerns and complaints about the sentencing system were exactly true in a pre-guidelines world, an entirely discretionary world, but it was all brushed under the rug of, well, we don't know what's happening when the judge, you know, sort of thinks about it for 10 minutes and then says 22 years or whatever they say. And so I think one of the values of the guidelines, regardless of what else you think about it, is it's brought all these issues to the surface. And so we can have discussions about it and we can analyze it and hopefully break down what the problems are. And I think for me, when I think about any criticism of the guidelines, the first question I ask is, well, was that true before the guidelines were in place? And certainly every defense attorney would say, yeah, my relationship with the prosecutor was incredibly important in figuring out whether I'd get him to, you know, say I'd agree to such and such of a reduction or things of that nature. And similarly, you know, the complicated mini trial over did that person actually have a gun or use the gun or shoot the gun? Well, that was going on in everybody's mind in one form or another. They just weren't talking about it. And I think the guidelines deserve some credit for forcing us all to talk about it. Now, it's also credit that's depressing because we see how hard and challenging and complex and sometimes disconcerting it is. And I think very much so the problem is when you have a commission sitting around talking about it, it's dangerously easy to focus on the crime and how bad the crime can be. And the instinct is, despite what I think is a very true statement of yours, that punishment really doesn't affect crime rates. The instinct is, well, gee, if this gives the impression that we're not being tough enough, well, there's going to be more crime, and so we better ratchet up the rates. And so without seeing flesh and blood defendants and experiencing the humanity of each case, it's inevitable that certainly Congress, I think even more of a problem, but also a commission which is only dealing with abstract entities, and the entities are criminals. They're not people. They're, by definition, figuring out what to do with criminals. You're going to get that kind of problem, but then to me, there's the saving grace of the judges. They're the ones who come at the system, and the prosecutor and defense attorney at the individual case level who can bring their humanity to the case. Now, it sounds like you're also depressed because that humanity is itself influenced by the disparity of our own different human conditions, and I think that's right as well. And so, as always, I tell my students, the whole world revolves around sentencing, but I do think it suggests you need to construct a system, and this is what I've spent a lot of my time writing about, where you make sure each entity is doing what it can do best. And so you make sure that Congress is simply setting the broad goals, and you make sure the Commission is identifying as many factors as reasonably can, but then putting that in a structure that judges can then bring to bear in an individual case and apply their own humanity in a valuable way that will have some consistency over the range of cases. And I like to believe the Sentencing Reform Act at least creates the potential for that kind of system to come out. Whether we actually have it, well, we spent 2 hours talking about it, so it's an open question.
We're getting close to our closing time, and I know from my days as a student here that the weekend began yesterday. So I'm going to try and ask a final question and give each of the three panelists a couple of minutes to respond to it. Actually, a two-part question. At bottom, has the new system been successful? And why haven't any of the states adopted the federal system? I'll start to my immediate left and work to my far left. That's you.
Well, I don't know about, I know about a couple of states, but I don't know about all of them. But just to recount a story about what happened in Wisconsin a year and a half ago. We had a criminal penalties study committee explicitly by the legislature charged with generating non-binding guidelines, right? These would be voluntary guidelines, but I got to tell you, boy, it was heated nevertheless. But one of the very first things that was said, and I suspect this is said in a lot of states, is everybody said, well, we're all agreed, aren't we, that we don't want to adopt the federal sentencing guideline system. Oh, yeah, that's right. Everybody said, no, we don't want that. Now, that was actually said by a former federal prosecutor, now a judge in Wisconsin, and seconded by another former federal prosecutor, now an attorney in Wisconsin. But what we did, oddly, after considering various other forms of guidance altogether, at the end of the day, what those two people did, those very same two people, was to create a system of grids whose complexity roughly matches the complexity of the federal sentencing guidelines, though the rules were not quite so complex yet. They had replicated, to a very substantial extent, the federal sentencing guideline system that they said we absolutely couldn't have, except they'd made it entirely voluntary, so it wouldn't be actually binding on them as they sat in judgment. Now, I have a feeling that happens a lot. There's something so alluring about some parts of that federal sentencing guideline system. Everybody's reduced to two variables. That's very convenient, right? There's rules. We got lots of rules. That's good. And we don't like the constraint on discretion, but it's a nice cover, isn't it, to have all that structure in place. And so I don't think states are likely to like the federal sentencing guidelines, but I have a feeling they're likely to adopt things that look on the surface very much like them.
I think the guidelines have been successful in ensuring, as I mentioned before, that we give the consideration that's due to this incredibly important exercise in both human judgment and sort of the imposition of the denial of liberty that is what the average sentencing experience is really all about. And so they've been successful in forcing us to confront a host of issues and a host of concerns that have always been lurking in the sentencing enterprise that have been dangerously easy to ignore, especially because, and this is sort of the liberal cynic in me, because the harms were being weighed upon the people we don't really care too much about, or we're not too worried if they're not getting quite the right kind of justice, or if there's disparity and discrimination in that realm, because it's not us, the fair-minded people who don't commit crimes. It's only the criminals who are being subject to this game of chance. And so, well, I feel very proud that the Sentencing Reform Act is part of a series of reforms across the country to break away from what could be a very dangerous vision of how we approach criminal sentencing. But I also think it was the most ambitious, and for that reason, the most fraught with peril. And that in turn has led to a number of states understandably saying, we're not going to go that route. I think helpfully, and this experience, your anecdote suggests the same dynamic, is states are coming to see that it makes some sense. What the guidelines are trying to achieve and what they are achieving has some importance and significance that should lead states, and more states are gravitating to some form of structured sentencing. But perhaps the federal system has led by bad example in highlighting that there can be lots of risks about being overly ambitious in one's approach to achieving those goals. And so I still think it is a model for the states, but not exactly the model that we might otherwise envision.
Well, I think the federal guidelines have been successful to a substantial degree in achieving the purposes that Congress had in mind. But I'd like to know more about how well they have actually achieved those various purposes, and my colleagues on the Commission would like to know more, and that's why, for one reason, that's why we have made it our business over the next couple of years to try to do something of a comprehensive assessment of the relative success or not of the guidelines in achieving those various purposes. In many cases, what we will be doing will be drawing upon the research of others rather than conducting original research ourselves. In some cases, such as measuring the effectiveness of the criminal history part of the guidelines, we hope to do original research because we are in possession of the data that can test whether or not that part of the guidelines has been successful in, for example, predicting which defendants, among others, will be more likely to recidivate and therefore should receive a higher guideline score in the criminal history part of the guidelines. As to why the states have not adopted the federal guidelines, I think it's a complicated answer. That some parts of it might be resource constraints in the federal system. We have not been constrained by prison capacity to the extent that the states have been. Congress has been quite ready. It has, in fact, appropriated more money to build more prison space, even though the guidelines, even though the Commission takes into account the impact of changes in the guidelines on criminal history, it does not act as any kind of a firm constraint on what we do. I think that's different at state level. There are other resource constraints that are important in the process. As mentioned, the pre-sentence process. Most states have a much less elaborate process of preparing pre-sentence reports. They don't have the probation officer resources that the federal system has, and the federal system depends for its relative success as a procedural matter on the work of the probation officer in doing, first of all, a workup of the guideline computations, which is then shared with the parties, and ultimately the court gets involved in the process in resolving disputes. So that, that's probably a factor. Perception of the federal guidelines as being a very harsh and constraining system, whether or not true, certainly has an impact on comments like, as Professor Smith mentioned, the comments of perhaps of the two former prosecutors from the federal system who were involved in the state systems. Certainly, that's a factor, and there probably are a number of others.
On behalf of the panel, I want to thank you all for your attention and your participation, and keeping in mind that Dean Davis is in Philadelphia, I hope you will leave here not sharing the views of W.C. Fields, who wanted as an epitaph on his tombstone, all things considered, I'd rather be in Philadelphia.
On behalf of the law school, I want to thank our panel very, very much. This has been a very interesting and informative discussion. We have a reception out in the main atrium here. You're all invited to come, have a drink, a little something to eat, and you can continue the discussion in a less formal way with this very interesting panel. Thank you again, gentlemen.
You were very good.
very good speaker.